5 seconds to go. Dictation will start. The main ground of challenge in the writ petition is that without determination of the actual market value of the land, the collector has proceeded merely on the basis of circle rate prevalent for residential plots and determined the deficiency in the stamp duty full stop. According to the learned counsel for the petitioner, the said property area of which is said to be 134 hectares has been purchased to increase his holding, considering the fact that the adjoining land is that of the petitioner, where cultivation etc. is being done by the petitioner full stop. It is also admitted that the said plot is Ghada, that is a ditch, and therefore cannot be used for agricultural purpose in its present state full stop. The contention of the petitioner is that the plot in question is surrendered by agricultural property in which agricultural activities are going on and no abadi is there in the vicinity full stop. Para, however, one boundary wall of the roadways stand is there, but that alone cannot be a determinative factor for treating the property to be residential full stop. Further contention of the learned counsel for the petitioner is that the collector has relied upon a report dated 24.3.2007, which is said to be of prior to initiation of the proceeding under section 47A under bracket 3 of the act, and therefore the commissioner erred in law in relying upon the same full stop. Further contention is that subsequent spot inspection report submitted by the sub-registrar dated 24.1.2008 clearly mentions that the property is agricultural, and therefore the order of collector treating the property to be residential cannot be sustained, as the same has been held to be so without any basis full stop. The matter was carried to the commissioner, but the commissioner also affirmed the order of the collector without interfering with the same full stop. The point for consideration before this court is that the property in question, which is held by the collector to be of residential potentiality, is on the basis of report dated 24.3.2007, but the subsequent report of the sub-registrar dated 24.1.2008 has given a finding that the property in question is agricultural full stop. I have heard Shri Pradeep Kumar Rai, learned counsel for the petitioner, and the learned standing counsel appearing for the state full stop. In my view, the provisions of section 47A under bracket 3 of the act clearly mandates that either suo motu or upon some report of any other authority proceeding can be initiated, and the collector, after issuing notice to the petitioner, can proceed to determine the market value of the property in question for determination of deficiency in the leviable stamp duty full stop. This court, in the case of Ram Khelevan alias Bacha versus State of UP, reported in 2005, RD 511 has clearly held that for the purpose of determination of market value, same principle has to be adopted as for determination of payment of compensation to the landholders under the land acquisition proceedings full stop. It is wholly irrelevant whether the said property has been recorded as agricultural in the revenue records or not full stop.